The applications were assessed on the parameters such as the techno-economic feasibility of the end-use project, status of preparedness to set up the end-use project, past track record in execution of projects, financial and technical capabilities of the applicant companies, recommendations of the state governments and the administrative ministry concerned. The process of competitive bidding could be introduced through administrative instructions. However, this required legislative amendments for placing the proposed process on a sound legal footing. In a democracy, it was difficult to accept the notion that a decision of the government to seek legislative amendment to implement a change in policy should come for adverse audit scrutiny. The issue was contentious and the proposed change to competitive bidding required consensus building among various stakeholders with divergent views, which was inherent in the legislative process. There was opposition from the major coal and lignite bearing states as they felt that it would increase the cost of coal, adversely impacting value addition and development of industries in their areas, and would dilute their prerogative in the selection of lessees. The Coal Mines Nationalization Amendment Bill 2000 to facilitate commercial mining by private companies was pending in the Parliament for a long time owing to stiff opposition from the stakeholders despite the elaborate consultative process undertaken with all the stakeholders. The Prime Minister further said that the CAG had computed financial gains to private parties as being the difference between the average sale price and the production cost of Coal India Limited to the estimated extractable reserves of the allocated coal blocks. Aggregating the purported financial gains to private parties merely on the basis of the average production cost and sale price of CIL could be highly misleading. Moreover, the coal blocks were allocated to private companies only for captive purposes for specified end uses. It would not be appropriate to link the allocated blocks to the price of coal set up by CIL. There were other important technical issues and other significant factors involved in the process which the CAG should have taken into account. The implicit suggestion of the CAG that the government should have circumvented the legislative process through administrative instructions over the registered objections of several state governments, including those ruled by opposition parties, if implemented, would have been undemocratic and contrary to the spirit of the functioning of our federal polity. The facts spoke for themselves and showed that the CAG's findings were flawed on multiple counts. Initiating the discussion, Shri Balbir Punj stated that the problem of Assam would adversely affect the security, unity and pride of the entire nation. He pointed out that deplorable conditions existed in the refugee camps with even basic amenities being unavailable. He demanded that the affected people should not be asked to return to their villages until they felt secure. He further sought information on the date when the violence erupted and the date on which the state government requested the Ministry of Defence to send the army in order to tackle the situation. He said that the responsibility to maintain security in the states along the nation's borders was vested with the paramilitary forces such as CRPF, BSF, SSB, ITBP, but a huge number of personnel have left these organizations due to political interference in their functioning and shattering of their morale. Referring to the major agitation in Assam in the 70s, Sri Punj stated that following the agitation, two main demands were laid down to identifying all the Bangladeshi nationals in the country and to create a national register of citizens.